sitting day. Call on Government Order of the Day number 5.
Juries, Jury Service and Protection of Particulars of Jury List Information Amendment Bill interrupted debate on third reading.
Members, when we were last debating this bill, Jackie Dean had the call and has 4 minutes 30 seconds remaining if she wishes to speak. The Honourable Phil Goff.
Mr Speaker, I don't blame Jackie Dean for not taking up the call. It's a fairly insubstantial bill and it's very hard for a government member to fill in 10 minutes speaking on it. Having said that, Mr Speaker, and wound the member up as I intended, I need to say that Labor supports this bill. When I said it's insubstantial, it was not of sufficient impact to warrant a regulatory impact analysis or statement. So that's simply a statement of fact. It's not a significant bill. It's been sitting on the order paper for 18 months since it was introduced. So the government hasn't been in any hurry to introduce it. But it does some useful things that bear comment, but it's not going to shake the world. The first thing that it does is that it prevents people who have served home detention sentences for 3 months or more from qualifying for jury service for 5 years. I think that's a sensible provision. It brings it into line with the fact that if you've served a jail sentence that you are prevented from serving on a jury. And there's a very good reason for that. If you're the sort of person that's committed an offence serious enough to have home detention for more than 3 months, you're not really in a great position to stand in judgment of another person's guilt or innocence for that period of time. So I don't think there was any great controversy around that. I think it deals with a problem in the earlier Act and it closes a loophole. The second thing that it does, Mr Speaker, is to empower registrars to permanently excuse from jury service people either who have chronic ill health or people who are 65 years or over. Now, where a person has chronic ill health, it makes sense that there be a permanent excusal. If the person is repeatedly ill, they're not going to be in a position, and it's a burden on them and a cause of anxiety if they keep getting summonses to appear on juries. The question of an over 65-year-old was somewhat more controversial when discussed at the Select Committee, and that was because from Labor's point of view, although we acknowledge that there's nothing in this bill that says a person can't serve over the age of 65, the bill, as it was originally introduced, said that if you are permanently excused because you're over 65, then that's it. You'll never, and you can never go on a jury again. And we had some problems with that. One is that it stereotyped older people and suggested that when you got to 65, and I'm sure you'd agree, Mr Chairman, that you're not past serving on a jury. In fact, there's going to be, in 20 years' time, something like 1 million people over that age group. And if you're going to have a jury of your peers, you're going to need to have a lot of those people with considerable experience and, most importantly, a little more time than others in the community to serve on the jury. I think the real problem we're going to have with juries is that, as more and more people seek to be excused because they have to work, they can't afford the time off, the jury fees aren't sufficient for them to serve on a jury for a week or 2 weeks without suffering from financial hardship, you might find that your juries become less and less representative of the community. But anyway, our problem was, and the report from the Select Committee suggested that the Select Committee was uneasy with the fact that once you had been excused because you're over 65, you couldn't reverse that process. Well, finally, the Minister saw sense on that and she introduced Supplementary Order Paper number 94, and that enables people who are excused permanently from jury service because they are of or over the age of 65 to resume being qualified and liable for jury service by having their permanent excusals cancelled as of right on a written application. So I think that was a sensible thing to do, and that resolved the concerns that we had with that particular aspect. The third thing was a more serious problem, and that was the concern that defendants could have access to the jury list, and the jury list provides the name, the occupation, the birth date and the address of members on the jury. Now, if a lawyer representing a defendant has access to that information, the lawyer is conscious of the obligations on him or her and is liable to keep that information secure and not divulge that information to the person that they are representing. But we have a problem, and it's going to be a growing problem because of cutbacks to legal aid, that more and more people are representing themselves in court. Now, I don't think that's a good idea, Mr. Speaker, and I don't think judges think it's a good idea, because it makes the court process more drawn out. If you're going to have a fair trial and a person doesn't understand the law but they're representing themselves, it'll take much longer, it'll cost a whole lot more, and you'll find that the cuts to legal aid are actually pretty counterproductive. But it's false economics, as my colleague Shane Jones has just commented. And the provision that has been made in this bill is as a result of a man who was representing himself in court, who had access to the jury list, and who subsequently decided that he would contact one or more of the jurors. And that is a situation that can't be tolerated, and it is a contempt of court. And this bill makes an effort to try to improve the privacy of the jurors by ensuring that a defendant that is representing him or herself doesn't have access to the particulars of the jury list. Now, that's good, we support that, but let's not exaggerate the degree of protection that that will provide to the jurors, because a person who is a defendant is going to be in court to hear the name of the people called out in the courtroom. And it doesn't take much of a detective act to then, well, you know, if your name's John Smith, I suppose it might provide a difficulty in determining which John Smith in the phone book or on the electoral roll is the John Smith that was on your jury. But if you've got a name like, I think I mentioned it once before, like Lindsay Titch, there's not a lot of them about, and you'd be able to. Well, that's unfair coming from an assistant speaker, Mr. Robertson, but. You're not going to have much difficulty in tracking that person down. So while this bill is worthwhile in what it does, it doesn't apply a great deal of effort or imagination to how you stop people Googling somebody, how you stop them looking up the electoral roll or the telephone book. And I think that it leaves the problem, at best, only partially addressed. So let's sum up what we've got in this bill, Mr. Speaker. We've got a situation where you can treat people who have on home detention in the same way as you would treat a person that has served a jail sentence, and that would be that you prevent them from serving on the jury for a period of time. You've got the empowerment of registrars to excuse people who can't and don't want to serve on the jury for very good reason, but we've compensated for that by saying an older person who is excused can apply to come back onto the jury list. And you've got a partial protection for the privacy and the safety and the security of jurors, but just that, only a very partial protection. So this is a bill that we'll support. But this is a bill that's not going to make a huge difference to the system of justice in this country. It deserves a third reading. The Labor Party in opposition has supported it through each of its readings, and it will support it in the third reading, but it's not going to have earth-shattering consequences for the jury system and people within it.
I call Julianne Genter.
Tēnā koe, Mr. Speaker. Tēnā koutou e te whare. Raised to speak on the third reading.